Welcome everyone to the 31st Open Seminar of the Chair of Commercial and Corporate Law. It's my great pleasure to welcome all of you who joined us, and I'm very happy that you are with us. Today we have great guest from the University of Turin, Professor Fabrizio Sudiero, that I will have a pleasure to introduce to you shortly. But first, I would like to thank our co-organizer, the Warsaw Bar Association, and I will pass the floor to Dr. Schmidt, who will also open the seminar on behalf of the Warsaw Bar Association. Dr. Schmidt, the floor is yours.
Welcome, everybody. Thank you very much, Professor Saida. On behalf of our Bar Council, as a Vice Dean of the Council, Warsaw Bar Association, it's my great pleasure to welcome you to the open meeting of our Department of Commercial Law. Today we have a privilege to host Professor Fabrizio Sudiero, who will deliver a lecture on the intersection of insolvency law and shareholders' rights. Well, the topic is particularly significant in today's complex business environment. The balance between insolvency proceedings and the protection of shareholder rights raises fundamental questions about corporate governance, financial stability, and the equitable treatment of stakeholders. Professor Sudiero's lectures promises to provide both, I hope, theoretical insights and practical perspectives, drawing limits between shareholders' rights, interests, and creditors. Upon insolvency, shareholders' rights to participate in management or decision-making, as we know, are significantly restricted. Strategic decisions shift to the insolvent trustees or administrator, reducing the real influence of shareholders. There is a fear of shareholders to lose their entire investments. Often in restructuring arrangement procedures, shareholders' rights may be modified, for example, by reduction of shares, conversion of instruments, and so on. So I hope the debate will be very interesting, and I pass the floor to Professor Saida. Again, thank you very much.
Thank you very much, Dr. Schmidt. We are very happy that we are consistently support our open seminars, and thanks to our cooperation, we already had great guests and great seminars. Our seminar today is kind of a next step in cooperation between University of Warsaw and University of Turin. You may remember that some time ago, we had a scholar in residence here, Mr. Francesco Mosetto from the University of Turin, who already defended his PhD thesis and also was appointed a judge in Italy. Then I had the pleasure to visit University of Turin and give a lecture there. And now we have a professor from the University of Turin as kind of the third step in our cooperation. Our guest today is Professor Fabrizio Sudiero, who is, that is not surprising for Polish lawyers, because he is at the same time a professor and a practitioner, a practicing lawyer. He is a professor at the University of Turin and also an attorney in Italy. He specializes in commercial law, insolvency law, and he teaches both in Italian and in English at the University of Turin. He published widely, mostly in Italian, on many different aspects regarding shareholders' rights, shareholders' liability, group of companies, and so on. And today, we are happy to be able to first listen to his presentation on the intersection of insolvency law and shareholders' rights, and then it will be followed by discussion. As usual for our seminars, we will start from the presentation for about 50 to 60 minutes, and then it will be followed by discussion. So if you have any questions or comments during the presentation, please write them down, and then it will be possible for everyone to take the floor and to ask your questions. I won't take any more precious time, and I will pass the floor to Professor Sudiero.
Okay, thank you, Professor Zaida. Thank you to the University of Warsaw and to Warsaw Bar Association for the invitation and for this important and wonderful organization for this event. Today, I have the pleasure to share with you some reflection regarding this topic that is related to the intersection of insolvency law and shareholders' right. In particular, I think that this topic is relevant not only from a national perspective, but also for an international private law perspective. Not only because we, in Italy, for example, we have now implemented the insolvency directive. I know that you are modifying your insolvency law also to implement the insolvency directive. And this topic, it is important because match two important aspects: property, that is to say the ownership, shareholders, and protection of creditors, considering the various different levels of value in insolvency law. So now we can try to have our table of contents. Therefore, first of all, we will see the issue. We go through analyzing the cornerstone of our discussion related to agency problems with a comparative analysis, in particular considering UK Companies Act and Loi Pacte in France. After that, the agency problem during the crisis, to therefore contextualize this aspect in crisis. In particular, considering two traditional principles that affect the position of shareholders. One is the well-known shift of fiduciary duties during the crisis, and after that, the general principle, the neutrality of crisis procedure on the company organizational rules. Later, we will see how the insolvency directive admit or sometimes oblige lawmakers and therefore the interpreter and also case law to derogate these two important principles. I bring you the Italian example that maybe for a comparative perspective could be interesting to understand in a concrete aspect what I'm talking to. And I try at the end to have some conclusion, in particular considering a sort of possible different hierarchical scale of value in crisis. It could be useful for scholars, judges, and lawyers, practitioners to understand or better to interpret law, our law, and also lawmaker, as you are in this situation. I think that could be important to have reflection on this aspect. Let's go through on the value in the crisis in general. We have the shareholders, therefore value of ownership, property. Secondly, creditors that are stakeholders, different from shareholders. Thirdly, other stakeholders, in particular employees, environment, economic system, that we can also consider the undertaking in general, the going concern, business continuity. In the end, we have not to forget, and we will see that will be so important for insolvency law, debtor and the so-called second chance that today, I think, anticipating my conclusion, it's one of the cornerstone of the new insolvency law directive. Let's go through. We have to understand the hierarchical scale of the value. Therefore, we can think about that we can find shareholder at the last step, creditors, undertaking, and at the top, maybe debtor, or other combination, debtor, shareholders, creditors, or undertaking, or debtor, property, undertaking, creditors. That could be normal to think about it. We are in insolvency law. All debtor, undertaking, creditors, and shareholders, the top. We don't know, or better, we have to see. Many other combinations? I don't know. We have to proceed. I'd like to anticipate my conclusion, and there we proceed in our route to understand it. I think that we have to distinguish target goal from protection. We have value to go and value to protect, and we have to match. So we cannot reason only considering goal. I propose you to think about reading the Insolvency Directive from these two perspectives, goal from one side and limitations. I think that the milestones to pursue two important goals is the undertaking business continuity going concern. We'll see why. Because if we preserve the undertaking, maybe we are able to protect creditors and also all stakeholders, including shareholders too, because we can maintain specific value in the company. But we have some limitation. We cannot, in my opinion, pursue the going concern if we risk to damage the shareholders and creditor minimum protections that I'm calling the property could be property because creditors are the owner of their credit and property because shareholders are the owner of the company. Property is not a goal, maybe we will see why, but is a minimum necessary protection, limitation to the goals. And where is the meaning to pursue this target is the so-called best interest of creditor and shareholder test. We will see why. And what is it? Anyway, what I think reading the Insolvency Directive, but also reading Italian law and other law in this perspective, what is at the same time a goal and the limitation is the protection of debtor. Is similar, something that could be a sort of paradox, but actually not. The second chance, the possibility to have a second chance has been considered by European legislator a very important value, maybe at the same time as the first goal and first important limitation to all other targets, apart from what? Protection of workers. Protection of workers is the maximum and most important limitation value to protect, okay? So this is not a pyramidal scale I propose, but this sort of scheme. Let's go to proceed. We have to start from the beginning, therefore from where? The agency problem. We have to start from that. During a period of not crisis, during, we can say, a brightness moment. So we have, as we know, as jurists and scholars, the important theory of agency problems. Agency problems consider the possible conflict of interest in the corporate law. And we have, therefore, to understand that we have the first conflict of interest between managers and shareholders. Manager to remuneration, to the career, shareholders to profit, first of all, to simplify for now. Second is conflict of interest among shareholders, majority and minority shareholders. They can have different targets to shareholder value, to dividends, or simply to reinforce the power of majority for their network, not necessarily for profit. Third, nowadays, in particular in the era of sustainability, we have possible conflict of interest between company shareholder and stakeholders, environment, social, and governance aspect. No? So the conflict between company and third parties in general. So agency problems can be solved normally between two theories, shareholderism and stakeholderism approach, we know, or contractualism or institutionalism. From one side, we have the shareholderism. It means that the interest of the company is the interest of shareholders. That we have to distinguish between profit, the interest to dividends, and also interest to the shareholder value. That is something different. No? Because if I reinforce the value of shareholder, in particular for the stock exchange company, is something that could be different from the interest to profit and distribution of dividend. Anyway, it could be considered shareholder interest. From the other side, we have stakeholderism. It means that the interest of the company is the interest of third party. It's something that has been argued in the past, in particular in Germany, but I think that nowadays it is now again important, as we will see, for the sustainability approach. Where is the point of compromise between these two theories? How, in general, scholars in Italy, and not only in Italy, for example, as we will see in other parts of the world, I will be curious to understand also in Poland, where you find this point of compromise. I know that in Italy and in England and France, they reach this point of compromise in the so-called enlightened shareholder value. What does it mean? We know. We have two important examples, I think, at the European level from a comparative approach. We have the section 172 of the Companies Act, and we will see in a moment. And on the other side, the very recent reform by the Loi Pacte in France with the modification of Article 1833. We will see later why these are important. Keep in mind that, as maybe you know, these two important rules have in common the fact that the director have to pursue the interest of the company, the for shareholder, but having regard to the interest of third parties. We have to add, most of all, to our discussion that today we have different instrument pressure from European law, that is the corporate sustainability due diligence directives, the corporate social sustainability reporting directive that oblige, apart from the omnibus stop the clock moment, but anyway, it remains the fact that companies, in particular of some big dimension, we can say, have to report and also consider in their activity specifically the interest of third parties, reporting the non-financial impact, but also mitigate, remove, and avoid negative impact on social, environment, and human rights. All this pressure, all this condition, and languishing of the value bring in the solution of long-termism. This is now, actually, we can say, the possible compromise between all situations. Let's have a look, therefore, to section 172, just to make an example. As you can read, director of a company must act in the way he considers in good faith will be most likely to promote the success of the company for the benefit of its member, therefore shareholderism, but also have regard the likely consequence of any decision in the long term, and company's employees, supplier, customer, and others. So community environment. So it is a long-term that has to consider also interest of third parties. And the reform, this important article on the definition of company, so it is a systematic, very important and teleologically important modification in France. There is also the translation in English. So every company should be managing its corporate interest, taking into consideration that quite similar to have regards of the Companies Act, social and environmental issues of its activity. So long-termism, I think that is shared. What happened therefore during the crisis? Because now we have to see how we have to consider in the darkness, we can say, in the twilight zone and in the darkness. Before was in the brightness, but in the darkness. We have to consider, first of all, the shareholder positions. We said before that we have to consider, first of all, the two traditional position of shareholders, the two principles, traditional principle. They suffer the so-called shift of the fiduciary duties. If we said before that the interest of the company is the interest of the shareholder, but have a regard to their parties, but anyway, the point of reference, the interest of the shareholder, During the crisis, maybe we will see if nowadays is so, but traditionally we say that there is a shift of fiduciary duties from shareholder to creditors. We will see later. The second important principle is the general principle of neutrality of the crisis on the organization aspect of the company, on their contractual position, on their powers. Let's see the first shifting of director fiduciary duties. Normally, no, the traditional principle. What happened? There is a moment in which we have this shift of duties that from interest of shareholder, in the sense that we said before, disappear and goes to interest of creditors. But when? Where is this turning point? When director has to do that? We have 3 points, and maybe today they are, as we will see, all 3 important. First one, loss of legal capital. I think that also you have a rule on legal capital because you are in European Union, therefore you have to respect this directive that we'll see. It was the second directive. Anyway, we will see. Second, insolvency. Third, crisis. Where is the turning point? One of these? All 3? Some of these? We will see. Loss of legal capital required to respect this rule, the rule of recapitalize or liquidate, roll rule. This rule is found by second directives as reformed in 2012 and now in the last directive that codified all directives that require that when we lose legal capital, shareholder must be convocated by director and they have to decide what to do, to proceed and therefore to recapitalize or to stop the activity and therefore liquidate. From this moment, maybe we have a shift of fiduciary duties because if shareholders decide not to proceed, therefore shifting fiduciary duties in protection of creditors. This is always traditionally. We have to see, the target is to see if nowadays is in the same way. And what about the definition of insolvency and crisis, the other 2 situations? This is interesting because we have not a specific rule that oblige each member state to define in the same way crisis and insolvency. Meanwhile, we have a concept or loss of legal capital, more or less, in all European Union. Here not, because insolvency directive leave to each member state to define the concept of insolvency and also of crisis that, for example, in Italy, we translate in likelihood of insolvency. For us, in Italy, insolvency is the incapacity of debtor to pay normally its debt. So, for example, if an entrepreneur has to pay his debt selling the most important machinery of his factory, he is insolvent because it's not a normal way to pay debt, insolvent. In the case of likelihood of insolvency, we are in crisis. This is important because also this aspect today is, in my opinion, relevant for the shifting fiduciary duties. We will come back later. Therefore, how can we think about it? Today, maybe the turning point and the shifting of director duty is a little bit much more complicated than in the past because we pass from, as we said before, shareholders to not only creditors, as we will see, but as we will see, creditor, business continuing, debtor, and discharge of debt. So today, the turning point that we saw before, loss of legal capital, insolvency, and crisis, all these 3 events are trigger events that bring to a shifting of the director fiduciary duties from shareholders to other value, not only creditors. Let's keep in mind this first, outcome, and we come back on this aspect because we have to see now the second traditional principle, we are considering the two traditional principles. Now, the first one was the fiduciary, the shifting, and we solved in a way. And the second one was the neutrality. We will see that also this traditional principle is changed today, in my opinion. We have in this situation, I think, in my opinion, also consider the Italian example, as we will see, a strong derogation by the Insolvency Directive. In particular, I'm referring to one aspect. As you know, the position of shareholder can be divided in two important ones. The monetary and economical one, so the interest to dividends and also to the quota at the end of the company of liquidation. So strictly economic and monetary position, but also we have a contractual position and a participatory position. And this is, for example, the right to vote. So the right to vote is a participatory contractual position. What was in the past, before the Insolvency Directive, in my opinion, was that the crisis cannot derogate or limit the power of shareholders, this contractual participatory position. Today, I think that Insolvency Law Directive allow this possibility. The possibility for that in order to solve the crisis, the director can, as we will see, can modify these powers of shareholders. We see this in the recital number 57 of Insolvency Directive. The point is that the shareholders, the creditors, but also the shareholders, generally called as equity holders in the directives, cannot unreasonably prevent the adoption of a restructuring plan in a way, I repeat, unreasonable. So it means that if, for example, and this is the important test to supersede, solve, is that they cannot avoid, prevent this situation, the solution of crisis, if comparing the alternative scenario, for example, insolvency, they can receive less. So we have always to compare, this is the best interest test, both for creditor and shareholders, we will see. When we decide, and the directors, we will see, decide to choose a specific solution, have always to consider the alternative scenario of insolvency procedure. And if a creditor or shareholder will be or could be treated worse in this scenario, they cannot oppose to this solution. So this is the best interest test. And not only of creditors, but also of shareholders. We have also an important key from an interpretation perspective, in my opinion, is we can read in directive, because we can see a possible prevalence of crisis law over corporate law. That's why it is possible to derogate to the principle that I said before of the neutrality of the crisis on organizational powers, because the directives in recitals 96 and the article of the directives state that, in fact, the crisis law could prevail on corporate law. And we can see from the very first part, the effectiveness of process of adoption and implementation of the restructuring plan should not be jeopardized by company law. In my opinion, it's clear that a solution that can solve or prevent a crisis can prevail on corporation rule, and in particular, right of shareholder. When director has to consider, therefore, the other interest than of shareholder, which kind of interest they have to consider? Only creditors? Again, directive help us to understand this aspect in 2 points. Preventive restructuring, so the necessary to prevent insolvency. Early warning tools. This is the concept. First one. Second, look, honest insolvent entrepreneur can benefit from a full discharge of debt, the so-called second chance. So the going concern is the rule, but pay attention because our directives, we can say our directives, states exactly that we have to preserve the interest of debtor to have honest debtor who obtain a full discharge of debt for the second chance. That is something that also is influenced by, you know, USA bankruptcy law from the Chapter 11 too. Yeah. So, what is the best interest of creditor and shareholder test? It was we said before. We need always a comparison between the scenarios. If we want to prevent crisis, we want to protect, therefore, creditor. Okay, well, if we do that, both creditors and shareholder can go against this solution, but considering only the alternative scenario. We have to see what they could receive in the alternative scenario. This is the best interest of creditor, in my opinion, also shareholder test. I come back to the previous one because this, okay, just to fix two aspects. Best interest is provided in these two parts. And these are important because these are two recitals always of our insolvency directive. The best interest test is focused in particular in the first part. Look, say, member states should ensure that the judicial or the administrative authority is able to reject a claim where it has been established that it reduces the rights of dissenting creditor or equity holders, it means also shareholder, either to a level below what they could reasonably expect to receive in the event of the liquidation of debtor business, so the alternative scenario. This is exactly the best interest of creditor and shareholder test. What is also important, the second part, recital number 47. If we decide, if we, in this case, in this example, our director, decide to solve a crisis to reduce, anyway, or to require to the creditor and shareholder to be sacrificed on something, we have to consider the alternative scenario, but we have to give the voice to them. In this case, in particular, for example, in the case of agreement with creditors or also shareholder, we need to put them in specific classes, categories, and allow them to express their vote. And how do we express their vote? Proportionally to their interest. So we have two filters, the best interest from one side, and the other side, the voice of them. We will see, and I anticipate one, I think, important aspect, that regarding the shareholders, they have to vote proportionally to their participation of legal capital. And what I saw, I had a conference in Italy regarding this aspect, and this our lawmaker didn't see, in my opinion, that implementing in a strictly way this provision has sterilized the multiple voting rights. Because if shareholder has to vote proportionally to their legal capital, we restore the one share one vote principle. That we know that through after the multiple voting right directive should not be a so mandatory principle, but now in crisis it come back again. We will come back in minutes on that aspect. Just as some example of Italian law, in my opinion, could be interesting. I don't know if you know something about Italian law, or by Italian system. Just in general, you know that we have we have one code today and various specific law. After the unification of Italy in 1861, we had two codes, commercial and civil code. In 1942, we unified the code only one, so we have the commercial law inside of civil code in a specific book, the number 5. But insolvency law stay outside from our civil code in a special specific law. This law was of 1942 too, but it was suffered many reforms by lawmakers that decide to adopt for the modernization law in the times and the case law. After that, we decided to reform this old law in the 2017. Before then the Insolvency Directive, we decided to reform. Later, arriving the Insolvency Directive, we had to obviously respect Insolvency Director, stay on the top of the sources of law, and we respect it. We modify our project, therefore, of law, respect insolvency directives, and we adopt the legislative decrees 14 of 2019, but not in the implementation of the directive, because we have to modify our legislative decrees in 2022, implementing the directive. And now we had a last, I don't know, but anyway, for now is the last modification in September of 2024. We have many instruments to prevent, early warning tools to prevent crisis. Here I leave you the instrument just for the musicality of words, so I can say composizione negoziata, piano attestato di risanamento, accordi di ristrutturazione, accordi di moratoria, concordato preventivo, piani di ristrutturazione soggetti a omologazione. These are all preventive. We have many instruments. I don't know in Poland, but anyway, we have many instruments to prevent what? The insolvency procedure, that is the extrema ratio. In the past, the insolvency procedure was called fallimento in Italy, but it has a very negative expression, significant, that is in conflict with the new conception, with the second chance of today. In fact, we decided to change the name. Today, we don't call it fallimento in Italy, we call it liquidazione giudiziale. Just a sort of maquillage operation, but anyway, just to express the difference of value of crisis, not a sanction, but a way to understand a mistake and the possibility to restart. Anyway, what happened in Italy? We have some rules in Italy that implement expressly what I said before. So the possibility of director to modify the right of shareholder without their consent, or better, their consent has to be expressed, as I said before, after the filter of the best interest and voting proportional to legal capital. And the directors are very protected because they cannot be removed otherwise than cause. So it's necessary the cause, a specific cause for removing them. Meanwhile, during the brightness, so without the crisis, the director in Italy can be removed by majority without any cause. Simply, if there is not cause, you have to compensate them. But the revocation, the removal is effective. Now, no. If the director decides to adopt a specific instrument or reduce right following procedure, company procedure, they cannot be removed or they cannot be removed only for cause. This is an important power that we Italians give to director. And you can see, not only the director have the exclusive decision, the shareholder cannot decide anything, we can say in this situation, to adopt or not the plan. The power is in the hand of director, and they can be removed only for cause. Not only, look, allows modification affecting shareholders' right. So, you remember, I said before that the two traditional principles now are derogated. We have not only the shift of fiduciary duties, but also we can modify the right of shareholder. And the decision of the court that validated the agreement with creditors that provide this modification of shareholder rights has effect, total effect, also as amendment of article association without passing from general meeting. As I told you before, the right to voice simply is in this sense. Shareholder has to be put in specific category. They have to vote proportionally to their legal capital. So with a sterilization of other powers of shareholder, multiple voting rights, so they can only vote proportionally of their legal capital. But pay attention, we have also to pass the filter of best interest. Or anyway, it's something really discussed today. We have not a solution because it's very young provision too. We have not case law for sure, or very, very few case law. So it's something that we are studying. I mean, result in suspension of multiple voting, I don't know, maybe, because if I say that the shareholder has to decide proportional their legal capital, and I think that we are sterilizing multiple voting rights and other rights. The fact is that this directive, you know, was arrived later than insolvency directive. So we have to see how we have to balance these two important concepts, no? And you have the example of the norms, the provision. Look, the access to a crisis insolvency regulation is decided exclusively by the directors. May provide for any amendment of the article of association. Directly affect shareholder participation rights. I think that is a very clear signal, you know, to where there is the power in crisis. They simply director have to inform shareholder. Fortunately, I mean, anyway, they have to inform. And the removal director is ineffective unless there is a just cause, as we say, a ground cause. As I told you before, the creation of classes is mandatory when the plan provides for amendment that directly affect shareholder participation right. And you can see later, each shareholder has the right to vote in proportion of the share of capital. So what I said before, one share of vote is restored. In fact, I said in this conference that the one share, one vote sets during the brightness, but it rises again during the darkness. This is what I said before, the court can, with this decision, determines the modification of article association. Therefore, let's go to conclusions that were not so short, but we arrive. So first of all, you remember I proposed the approach to consider the new hierarchical scale of value, consider both the target, so what to pursue, and to protect. Pursue and protect are two different aspects, because one side is the target, on the other side we have the limitations. So what we have to pursue? Sustainability, going concern, employment, environment, for sure. Debtor second chance, and in my opinion, debtor second chance is the freedom. At the end, creditor rights, property, is a sort of paradox, but it seems actually that it's true that creditor is the genetic cause of a procedure, but maybe it's not at the top of the value to pay attention, pursue. But if we go to the value to protect, we can see at the top the debtor second chance. I think that is clear. Because, for example, in Italy too, to obtain the full discharge of debts is not necessary to pay creditors. You can obtain this full discharge of debts also without paying creditors. And it is allowed by Insolvency Directive. There is a specific norm that you can see that say that if a member state condition the full discharge to a payment of debtor, of creditor, therefore This means that, therefore, you can also not pay the creditor to obtain the second chance and therefore to fully start. Second value to protect, not to pursue, is the property shareholders and creditors' right. We have a minimum protection for them. That is solved by the best interest test in both cases. Thirdly, actually, it is a target, but maybe can be sacrificed, because if the solution that we see doesn't supersede the best interest test, we cannot necessarily preserve the going concern. We go in liquidation. And as we say before, related in one share mechanism. Creditors there no warrants the liquidation, is what we said. Contractual shareholder value test to fairness as a sort of clause, general clause. Conclusion regarding, therefore, the hierarchical scale. Regarding the value to pursue, we have on the same top, we can say sustainability and freedom, in the sense sustainability and discharge of debt. Regarding to pursue, I repeat, property, creditors' right, in this sense, property in the perspective of creditors, is a value to pursue, but not at the same level the other one. Regarding to value to protect that are unimpressible, always freedom, discharge of debt. I think creditors and shareholder in the sense of best interest. And workers in general always to be protected. In fact, we cannot imagine a full discharge for workers. Okay. Sustainability, therefore, property and freedom. These are both the value that can be protected and pursued are freedom in the sense full discharge of debt. Freedom, just to be philosophical perspective, I mean, second chance, freedom, creditors' right, yeah, sustainability. Shareholder is not a value to protect and pursue, just only to protect, not to pursue. We can. Therefore, we come back from the anticipation of my conclusion. Therefore, I think that now is clearer than before that in my personal opinion, and it is reflected in insolvency law directive, the insolvency directive, but insolvency Italian law, during the darkness, I mean, in the case of insolvency, we have a milestone, an ideal, important value to consider is the undertaking, the business continuity. We read it because it helps us to pursue at the same time both interests of creditors and stakeholders. For sure, if you find a solution that preserve the going concern, it could help creditors and stakeholders, employees, and so on. But not at all costs, with limitations of properties, with the minimum protections, both for shareholder and creditors, protection that is represented by the best interest of creditor and shareholder test. A minimum protection with the comparative scenario, alternative scenario, is always necessary to do. But anyhow, what I think that in the end of the story we have is the full discharge of debts for honest debtor. What I mean honest, each member state has its own specific law, but for example, for specific criminal sanctions of bankruptcy crime, no, it's not covered. I mean honest in the sense. And anyway, with the thank you for your attention. Interrogato.
Thank you, Professor Sudiero. It was very inspiring and very interesting. And you prepared great slides because you developed the entire theory. So the slides helped enormously to understand how you went from one point to the other. And I think that it's a great material for a paper that you could develop kind of a conceptual theory resulting from the analysis of Italian law as an example, as a starting point to develop all these steps that you could that you showed us. Now it's my pleasure to open a discussion, and if anyone has any questions or comments regarding the issues, please raise your electronic hands, and then I will have the opportunity to give you the floor. If you cannot use your mic, you can write your questions on chat, and then I will be able to read the question. And I see the first question from Dr. Tomczak. This question is on chat, so I will read this aloud. Dear Professor, thank you very much for the interesting lecture. Do you know whether there are any explicit sanctions under the UKCA or the FCC for breaches of Article 172 UKCA Company Acts or Article 1833 of French Civil Code? That is when a director, in carrying out their management duties, fails to take social or environmental issues into account. And I think that first we will try to gather some questions, then I will pass the floor to ask you to answer the questions, and then we may have kind of a next round if there are more questions. I see Professor Herbert from Catholic University of Lublin. Professor Herbert, the floor is yours.
Thank you very much, Professor Sudiero. Thank you very much, Konrad. I have three questions. The first one would be very brief. I just need to be assured what happens if the outcome of the best interest test for the creditors and shareholders is different for each of these groups. For example, when the changes provided in restructuring plan are beneficial and desirable for creditors, but they are not beneficial for shareholders. According to my point of view, as I understand it, the axiology of insolvency law requires that priority in this situation should be given to the interest of creditors. Nevertheless, but I just want to know your position. The second question is more in-depth going, is more detailed, because I would like to ask you what is the concept, or is there any in Italian law, the concept or the structure of debt to equity conversion during insolvency or restructuring proceeding? And what is your experience? What is your position on the issue? Because under Polish law, we have, of course, such a possibility, but in my view, this possibility, since conversion is made without the consent of shareholders, there is only voting of creditors and approval of the court. It is increasingly common used for hostile takeovers of companies by third parties or even by one of the shareholders being in conflict. And the third question is, do you think there is an axiological justification to break with the principle of shareholders' non-liability for the company's obligation in the context of insolvency or restructuring proceeding, especially if the company belongs to a group of companies. Does it change anything in the context of non-liability rule? Thank you.
Thank you very much, Professor Herbert, for excellent questions. As I see no more question, I will add one more from myself, and then I will pass the floor to Professor Sudiero, asking for comments to the questions. What you described in Italian law, and you named it very nicely as a kind of dark time for the company, then for me it looked like the war zone, in the sense that the company is in crisis. So then we need a strong leadership, and then the power of directors is stronger, the power of shareholders is limited. We go back to one share, one vote principle instead of some more powerful shareholders. It's more difficult to remove a director because you need a cause. So it sounds like, okay, we are in crisis, we are in war. So our democracy for the company is kind of suspended to some extent, because we need a leader ahead who will go through the crisis and then restore the company and restore democracy for the society. If you could see this kind of a comparison between the situation, the crisis and the war, then there is a question about liability of directors in case of crisis. Because if you give more power to directors during the crisis, how it is connected with liability? Are there any special rules regarding liability of directors for their decisions in crisis? For example, do they have to, at some point, file a bankruptcy petition? Because in some countries, like for example in Germany or in Poland, we have the rule that when company is insolvent, then each director is obliged by law to file for bankruptcy, file for insolvency. And if he or she does not file for insolvency, he or she may be personally liable for the damage caused by not filing for insolvency. Then, in case when you compare the bright time and dark time from the perspective of liability of directors, what changes here? So I think that it's kind of the first group of questions, and I will pass the floor to Professor Sudiero.
Okay, thank you so much for these actually 9 questions. Very, very interesting, in my opinion. I hope to be able to satisfy your curiosity, but also meanwhile, I thought how to respond. I reflect on some possible solution, answer, and to discuss. First of all, Thomas Tomczak, sorry for the pronunciation. I think that is quite interesting question, and I think that I try to respond to this answer in general for the possibility of third parties in general, apart from UK and France. I mean, to solve the possibility of third party to be compensated for choices of share of the directors in this situation. In the case but I no mean in the case in which, for example, a director take a decision that directly damage a third party. In this situation, we have a specific rule, for example, in Italy, but I know also in France, I think also you, that is the responsibility of director for damages that cause directly to third party. I think that your question is interesting because the question is not if a director directly damage someone, but if in the business judgment rule approach, decision therefore which kind of interest to pursue, decide to pursue a lucrative interest of shareholder and not an interest of third parties. But also, I think that could be interesting in the opposite perspective. Do the shareholder or the shareholder are able to sue director that decide deliberately to pursue interest of third parties? I try to give a solution. I propose this solution in a paper that I wrote that unfortunately is all in Italian, but anyway, and I argue the possibility to create or to imagine a different subjective position that I taken by administrative law in Italy. In Italy, I don't know, in Poland, anyway, if you, for example, ask to a public authority a permission, you are interested in the right way to conduct the procedure. You have not the right to obtain the permission, but you have the right that the procedure to give you the permission is fair and correct. This is called legitimate interest, interesse legittimo. If, for example, a public authority fail this procedure because prefer another subject or doesn't give you the authorization, violating the law, you can challenge this decision and also you can require damages to the public authority. You have not a damage, but you have an interest to the right procedure. In my opinion, third parties interested in sustainability are able or could have this similar position in the sense that they have the interest that directors choose well, choose in a fair way if pursue a lucrative interest or interest of party, but they have to do fairly. This is very important, in my opinion, for the corporate sustainability due diligence directive. It is to say that directors could be considered directly responsible toward third party, but not because third parties have specific rights to be protected in the sense not to be damaged. This is obvious, but that director pursue their interests. But third party have to be interested to a right decision in the sense fair, correct decision. So I hope to answer you. Therefore, I think that third parties have not a specific right, a position, but a sort of intermediate juridical subjective interest. Okay? And no, okay, I can proceed with the other question.
And then she may come back, yeah.
The other question comes from a professor of Dublin, Herbert. Okay, thank you. These are three very inspiring questions. The first one is the conflict between shareholders and creditors. In both cases, we don't supersede in a way the best interest test. It is very interesting question. I think that we have not, so I'm not prepared to give you an axiological, maybe general answer, but maybe more technical one, I think. And later we can discuss if we can, from this solution, rise a principle. You know that when I say before in Italy, for example, but it is a solution that is founded in Insolvency Directive, when director decide to comprehend, to restrict the position of shareholders have to be collocated in a specific category. So shareholders are considered as a specific category of interest parties, as creditor. Therefore, we will have, for example, the bank creditors in a specific category class, the suppliers different from banking and the other class, and shareholder affected by this solution. In this situation, we have therefore three classes of interest party. They have to express their vote, and they have to express their vote at majority. So in this situation, I think that is the majority can win. And the crammed down solution could operate for the dissenting subject of a specific category, but I think that the majority win. Second question, yeah, the equity conversion. Yes, it's something that is possible also in Italy. I think that today, anyway, before that, these rules that I mentioned before, regarding the possibility of director to decide for the future of the position of shareholder, it has not specific rule. The problem was, do the director can decide in this way, or we need the consent of all specific shareholder? Maybe in the past, yes, because we have a specific position of shareholder. Today, it is procedimentalized. We have a rule that could be solved in the above way that we say before. Therefore, in class, it may be also the conversion should be a sort of expropriation, sure. Thirdly, I don't know if I understand well the question. Maybe I apologize. Anyway, I think that what you mentioned is the problem of the piercing of corporate veil in group of company. We have this theory too in Italy. Well, actually, it is interesting because the possibility to directly enforce for creditors their right to shareholders, and in particular to the majority shareholder, is a general principle of the, in Italy we call abuso della personalità giuridica, so the abuse of legal personality, this is transaction in Italy, and the person the corporate veil. Actually, we need in Italy the proof of the abuse. The simple fact that a company is insolvent cannot allow this possibility. We need to prove. We have not a specific provision, or better, we have a specific provision, but in a very specific and not used instrument that are called, I tell you in Italy, the patrimoni destinati a uno specifico affare. It is possible for a public company in Italy to create an autonomous asset to develop, carry on a specific business, and with this segregation, only this patrimony, only this asset respond for this debt. There, we have a specific rule that is the sole rule in Italy for the abuse of the legal personality, is the sense that if directors, or better, the company, doesn't give to this autonomy the enough assets, all company can respond for the debt of the autonomous patrimony. So I think that this could be in Italy possible answer to your question. If I
but the general regulation, the general solution, you have you have the general solution not only for insolvency procedure, but general for the whole corporate law. And one more question is, if I may, is it common in practice to use this this instrument, abuse of legal personality?
I integrate my answer in this way. We have also another. I'm a lawyer also of bankruptcy administrator. Therefore, I have to reach some creative solution to what happens sometimes that, for example, a company close and open in a different way, but near closer with the same shareholders. It's very common. I think not only in Italy. But in Italy happen in particular, not yes, in particular in South, but I think that's all I saw in Milan that it happens, and we can find various solutions. I apply in my practice activity many times, also not only for the abuse of legal personality, for another aspect. It is called a new and a different institution, and we have in company law. That is the so-called, I tell you always before in Italy, later I try to translate, super società di fatto. What is it? Is the super company, de facto company, super de facto company. Therefore, we have various subjects that are connected, and there is a sort of factio societatis between them that create a sort of the same company. And in this situation, we can apply the same rule that allow the possibility to declare the bankruptcy from the company and in extensions of each members, because it is a sort how in English is a partnership, is the partnership. So a requalification of all these subject in a super partnership, de facto partnership. And this is quite common. We have a case law that admit it also because the law provide this possibility. The problem is that we have to, the case law require the rigorous proof of three elements: common of assets, common of intention and participation to loss and profits. Third, the effects of societatis, that is all and nothing. It's quite difficult to demonstrate. We can do that by specific signals. We can do that. What is very difficult now for case law practitioner, but also scholar, is to distinguish a super società di fatto, therefore super de facto partnership, from group of company. Because in the case of group of company, you in Italy can only sue the holding for damages, but it's quite different from extending the insolvency procedure, because you have to prove the damage. So it's something difficult, because also in Italy you can access to an insolvency procedure with a group. So you can, the holding can decide that also holding company, the parent company, and also the subsidiary can go in or can choose a specific instrument. But so it is possible. Therefore, today is also difficult to understand the border of these two institutes, because the consequences are totally different, as you can imagine. It's very easy once that you demonstrate the existence of the de facto partnership, you can enforce the creditor's right and the procedure right in all assets. On the other side, if you don't demonstrate it, demonstrate only the group, you have to prove the damage and enforce the parent company. Okay, so three questions, yours question. I would like to introduce another metaphorical aspect. We have bright, we have darkness, but we have the twilight zone. This is very used as term also in scholars. The twilight zone is the situation that insolvency directive wants to focus in particular, because the early warning tools, the earlier you intercept the pre-crisis situation, the better solution maybe you obtain. Regarding your specific question, I think that the orientation of the scholars is in the sense to apply in each situation the business judgment law. And consider that in Italy, director never respond for debts of the company. They respond always for damages. We have a specific rule, that is the rule, if you want to write down, this is 2486 of the Civil Code, this article, this section, that provide a sort of presumption in favor of the bankruptcy administrator that for the quantification of damages, because what is very difficult is to quantify the damages of the director. If a director, for example, continue to manage the company after the loss of legal capital, in this situation, shifting fiduciary duties, but also we have specific rule, that is the rule that I mentioned before, the norm, the article, that say that from this moment, it is prohibited for director to proceeding going concern, has to proceed therefore liquidating. Today, I add liquidating or to access to an instrument to solve. And in this situation, this rule provides a specific presumption for damages in this sense. I try to explain if I can. The differences between the asset, it's called patrimonio netto, legal capital plus reserves. In the moment, you have to do the differences between the assets, total assets, in the moment of the insolvency declaration and the moment in which you lose the legal capital. The differences is totally a damage that has to be paid by the director. We have this particular presumption in favor, presumption that can be won, but can be won by the director. Sometimes I find myself as a lawyer of bankruptcy administrator. That is easier. It's simply you have to demonstrate that in a day you lose the capital, you proceed to manage ingoing concern, and I do the differences between. I have to rectify the balance, for sure, there are many technical aspects, simply the differences, and I ask you, as director, the damage. You have to prove that it's different. If sometimes I find myself in the other situation, and I understand the difficulties to rebuild, to construct the defense, so difficult. And if the books are not diligent, right, used by the director, we have also a worse presumption in favor of the director, because you can require to the director the differences between passive and active uncertainty during the insolvency procedure. So it's sort of sanctioning damages. So to respond you, not for that, for damages in these cases, but in general, I don't think that the liability is stricter in this case. Simply, we change the point of reference, therefore the complication is shifting, which kind of value. But we argue, scholars, about Keynes law, yes, more or less. In particular, you know that we have specific important court of Milan, that normally think to be stronger than Supreme Court. Sometimes happens, but anyway, stronger in the sense can give their interpretation. Sometimes we see, but anyway, it's a sort of joke, not so joke, anyway. But we think that we have to continue applying the business judgment rule, so the impossibility to syndicate the merit of the choice of director, both in the darkness, in brightness, in the twilight zone. What is changed is the point of reference.
Just a short follow-up question. Who can sue in this case? Only the bankruptcy administrator or every creditor individually?
Depending on the damage, if the damage is suffered by company and creditor, we have a sole legitimacy of bankruptcy administrator. Therefore, the damage to company is easy to understand, is a damage to asset. The damage to creditor is the impossibility of creditor to be paid in the consequences of damages to the companies are reflected damages. In this case, only the bankruptcy administrator can sue. It's different from, indeed, what sometimes creditors try to argue, that there is a direct damage. And this happens in particular when, for example, the company is insolvent. Notwithstanding the insolvency, the director is able to, with the dolus, to obtain from the supplier activity and so on. So in this situation, the supplier can imagine that there is a sort of responsibility, direct responsibility of the director, but it's very rare situation.
Excellent. Thank you very much. I see another question. Professor Nowacki, please go ahead.
Thank you. I must say I'm quite skeptical about this new shift in the fiduciary duties of the directors. And the reason why I'm skeptical is that I believe that the stakeholders have huge problems with enforcing these duties if we say they are the beneficiary of those duties. And at the same time, even if we introduce changes like you discussed in relation to Italian law, the previous beneficiary of those duties, which is shareholders, they still retain a lot of power over the directors, even if they cannot dismiss them without cause. Let's think about remuneration, for example, or let's think about claims for redress of damage, right? In many cases, that situation in which the company found itself may be the result of controversial decisions from the past. So I think, to sum up that part of my opinion, I would rather prefer a scenario in which the only duty of those directors really is to file an application for restructuring or an application for insolvency. And we might consider a shifting forward the requirement when that application should be filed. But then the situation is more or less clear. So we have directors that more or less are looking after the interest of the shareholders, as it always happened. And at the same time, we have other entities like creditors themselves, like a bankruptcy trustee, like the insolvency court or the restructuring court or the restructuring supervisor, that are bound to look after the interests of the creditors. That creates a clear-cut situation for me, and I would be in favor of that. Maybe considering the possibility to make it a little bit faster, so that the decisions are not made too late to save the business. That's point number one. And the point number two, I'm also skeptical. Well, today I'm pretty skeptical about many things. Pardon me. I'm also skeptical about this issue of second chance in general, talking about sustainability. And I think it's a matter of a fashion, because we see different trends every couple of years, and we go in a certain direction only to move back after it fails. That's my impression. And when it comes to sustainability, my point is, there's a lot of problems with these businesses. It's very often not a single problem of a temporary lack of solvency. And it's very difficult to solve all those problems. And we may continue the life of a business that has very deep flows, right? And in this way, what we create is we create problem for next creditors, right? We create problems for employees who cannot count on long-lasting good jobs where they have future, right? So we seem to be happy because the business survived another 2 years, blocking maybe the place on the market to other businesses who are not in such a good situation because they had to pay their creditors in full, right? So I'm skeptical. I'm not saying it should never happen, right? But I just think we need to find a proper balance, and we may find ourselves now in a situation when we just talk too much about it. Maybe that balance is switched in too much tilted towards survival of the businesses that have very deep flows. And we would be better off as a society and different parts of that society, starting with creditors and ending with employers and the taxpayer, not allowing this, rather, saying ourselves the truth. There's no future in that business. Let's make a place on the marketplace for a different business. That will be sound. And not all of these flows can be eliminated as part of restructuring, right? We may do a lot, but not everything can be sorted out. Thank you very much.
Thank you very much, Professor Nowacki. Also, Mr. Dominique, please go ahead.
Thank you very much. Thank you, Professor, for a very inspiring lecture. I wanted to ask, in more general, maybe it's little bit philosophical question, but don't you think that European Union goes in a very bad way in a matter of inflation of our regulations? Especially, I'm curious about your opinion about new Insolvency 2, about new CSRD, and about ESG rules, maybe the last one at least, but I'm pretty curious what Italian academic and what Italian practicer would say about that impact for your market and for your legal regulations. Thank you.
Thank you. I see no more questions. So the final comments, I pass the floor to Professor Sudiero.
Thank you. Yes, I think that for the first, that are no question our position, and therefore, yeah, I respect and understand the skeptical. I think too that, in my opinion, we have not to abuse this second chance. If I understood well the question in general, the position, and also the risk of empty protection for system relating to this aspect. I think that is something of political choice, but European Union, I think that is quite clear that the target is to pursue the going concern if it is possible. In Italy, for example, but also because it is allowed by the Insolvency Directive, we consider the business continuity also in an indirect way, in the sense that it is better to allow the possibility to benefit from a preventive restructuring framework than the liquidation, the insolvency procedure, if it is possible to sell only a part of the business, maintaining anyway, preserving the continuity. So it is allowed, it is considered a positive value, because the assumption is that a business in continuity can be better for the system. I don't know if it is a right solution. Yes, I think that could be. I agree that we are protecting maybe to some situation. We have also some restriction on second chance, for sure, not for each situation. I think the honest one, and also with some limitations, you cannot obtain the full discharge of debts many times. You have a limitation in general provided by Insolvency Directive. We have in Italy, depending on circumstances, the times that you can. But yes, it could be, I understand it could be skeptical, but the skeptical from a question of axiology and assumption, because actually the protection of creditors and sustainability in third party in this situation could be not for the compensation, that could be, but in a way for the decision of the judge. If, for example, decide for an not out of court procedure, but simply an agreement to be verified by the judge and certified, Italy is, for example, l'omologazione of an agreement with creditors, the judge has to decide for the cram down, so to oblige specific creditor to accept a solution, and also subject interested as the shareholder in this situation. So apart from the damage, the alternative scenario is considered from a decision, not compensatory decision, but a real decision in the sense to pass or not the solution. And I use this also position to make a bridge with the question, your question, general question regarding philosophy. I think that I don't know if we are going in a bad. I'm not the capacity to say so. I think anyway that we have to pay very attention on this aspect to avoid the so-called green bankruptcy. I think that it is important to reach an equilibrium between external sustainability, so they affect impact, but also the interest of third parties, the green and so on, because we have expensive. There are many fulfillment from one side, but we also to consider the internal sustainability, so the economic equilibrium of the company. The risk, therefore, is that to protect third parties, you become insolvent. And I call this one not high. I think that in particular international literature in German is talking about now someone of the green bankruptcy. So I don't know if we are going bad. I don't want to take position on Trump approach because I don't totally understand for some aspect anyway, but regarding European perspective, I think that we have to pay attention to green bankruptcy. But I think that commercial law, business law, is the key, in my opinion, from a philosophical point of view, is the key to promote a sustainable success, because commercial law has not boundaries, has not. You can decide to restrict or not the sustainable the values, but lex mercatoria, I think that at the end can export values, because we have not limitation, political limitation. No? That's why it is so important, sustainability in commercial law.
Excellent. Professor Sudiero, once again, thank you very much. As I said before, it was a very interesting presentation, slides, but the discussion was even more inspiring. As you could see, it was much, much broader than the topic that you covered. And thanks to your thoughts that you shared with us regarding Italian law and some Italian practice and some concepts, especially for me, very interesting concept of de facto partnership as a tool to kind of find liability of companies that are similar to a group of company, but are not the very group of a company. They are all inspiring, and they all prove that law is a very specific discipline of science. We don't have Polish physics or Italian physics, Polish chemistry or Italian chemistry, but we do have Polish law and Italian law. And then when we compare different solutions developed in different countries, we may end up improving our legal systems and learning from each other. And these opportunities, this kind of seminars, is a great tool to achieve this goal. So once again, thank you very much for coming to Warsaw, unfortunately with some issues and some bad weather, but still, I hope that it will be just the next step, not the last step, to build further cooperation between University of Warsaw and University of Turin, and we hope to have you back during another seminar in the future. I also would like to thank all the participants, especially those who took part in discussion, for, as always, extremely difficult and interesting questions that develop the discussion beyond the borders of the topic of the presentation. And I'm happy to announce, first of all, the next seminar in this series that will be organized in spring. And according to our schedule, the next seminar will be more focused on practice, and our guest will be more practitioner than academic. It will be a Polish lawyer from a big Warsaw law firm, Dr. Bobrzyński, who will share with us some experience, mostly concerning capital markets. And in the meantime, we organize also seminars in another stream focused on wealth management. Tomorrow, we will have a presentation and a discussion focused on tax aspects of private foundations in the light of possible reforms and kind of the way forward from what we have now in our law. Thank you very much. Have a good evening and until next time. Thank you.